Colleagues, what I want to talk about today, and hopefully you can all see my screen now, is this question about quality. Now, in South Africa, of course, we've come to know that by the word functionality, I prefer to stay away from that word, because functionality is a very specific way of looking at specifications, and in the broader literature beyond South African shores, functionality refers to a very specific quality within the broader notion of criteria, talking about how do you define or describe your need in functional terms. So that's, you're not describing what it is you want them to give you, you describe what is the problem you want them to solve, or what is the function that the particular supply needs to achieve. So functionality is a little bit of a misnomer in South African procurement terminology, but okay, this is the term that we've now used for some time. So I think most people in South Africa, at least, are familiar with what we mean when we say functionality. What it really is quality. It's about the substantive quality of the bid. When we measure your bid against the specifications in whatever form they're prescribed, where do you land? What is that substantive quality of your bid? And the question that I want to talk about today is, how do we deal with that quality element, or then functionalities, we use it in our final tender award decision? What role does it play? Both in current regulatory environment, but then also thinking a little bit, what does this mean going forward? And the question really is, should quality or then functionality only be an upfront stage one analysis, and then once you've passed through that stage, it no longer plays any role? Then after that, we use something else. Or should one also include quality in the adjudication phase, right? So you're also going to compare the bidders based on quality. The quality is also going to influence your ranking. Or yet another alternative would be to say, can quality come in at the end? After you've done everything, you've done a preliminary ranking, can you then go back to quality and say, okay, seeing what we're seeing on the ranking, but then also taking quality into consideration, this is the final award decision, right? And there are, of course, many potential variations on that theme. And the question is, where do we fall? Where do we place this? Now, this is a design question, right? There's no right or wrong per se. There are different ways of doing this, and different systems approach this differently. And in the end, it's a design question. It depends on what design choices did you make in your particular procurement system, based on whatever principles there are that you are trying to achieve by way of your procurement system. Now, the reason that I've been kind of grappling with this the last few days, again, is not a new conversation, but it's kind of landed on my desk again in the last week because of a judgment handed down by the Cape High Court last week on the 5th of March. And this is the judgment, Mpuzi Business Enterprises versus Eskom Holdings SOC. And this again raised squarely this question about quality and function. Back fairly old debates now about this, where I've also published a few thoughts on earlier developments, and again, this has been at the top of my mind. So I thought, let's think about this again. let's look at this case and let's interrogate what's going on here. And I think perhaps most importantly for where we are in terms of our own development of procurement law, where do we want to go? Because we are, of course, now on the point where we're redesigning. So what lessons do we draw from these recent experiences that would guide us in our new design? Where do we want to land? So those are kind of the things that I want to really talk about today. So let me quickly tell you about this case. Mpuzi Business Enterprise, CC versus Eskom Holdings, SOC. This case involved a tender that Eskom invited for a 5-year framework for vegetation management services, right? So this would be an open contract arrangement, a typical as and when arrangement. You're all familiar with that, for a 5-year period where the supplier would be called upon to do vegetation management for Eskom on various properties relating to Eskom services. And this is kind of clearing of vegetation. The way that the adjudication methodology was set up in this tender was across 3 stages. The first one was the normal compliance stage. Did you submit all the documents, all of that normal thing? And then stage 2 then went to functionality. And in the functionality assessment, the tender said, this is how we're going to do it. We are going to score all bids out of 100 points. And you need to achieve these 2 thresholds to be able to proceed to stage 3. And they were 86% on bush clearing and tree felling, and 70% on weeding and herbicide, substation weeding and herbicide, right? So these are the 2 kind of technical aspects of the specifications of the bid, and it had a methodology how that is to be assessed on every individual bid based on a point system with scoring, and it generated 2 sets of points out of 100, and those are the thresholds. And then when you've passed through that, you've met that threshold, then went into price and preference in stage 3. Now, at this stage, and this is quite relevant for the discussion, the price was prescribed. So there was a tariff written into the invitation, so there was no variation on price. You couldn't put in your own price. This is what Eskom was prepared to pay. So the price was fixed, but of course the preference points were not fixed. It was set out. They used the 80-20 formula. So in stage 3, the competition was really on the specific goals, on the preference points out of 20. That's where the action was, because everyone's prices would be the same, so everyone would be scoring 80. That's it, right? So that is, that's the background. Then Eskom awarded this tender, and Mpuzi Business Enterprise, who was one of the bidders, who made it through stage 1 and 2, lost out. And they were informed that they did not win the tender. Another bidder was awarded. They then brought challenge. And the relevant part that we want to focus on relates to their challenge about the final award decision, which had to be taken in the end on a deadlock breaking approach. Because what happened, and this is not surprising given how stage 3 was set up in this particular case, was that multiple bidders achieved the same number of points in stage 3, which basically means they had the same score on the specific goals, right? Remember, price is fixed. So out of the 20, they scored the exact same number of points. And Eskom accordingly had to use the deadlock breaking mechanism to determine who's the winner. Now, of course, I'm sure you all know that there's a prescribed deadlock breaking mechanism under the PPPA in the Preferential Procurement Regulations 2022. This is it, Regulation 8. And Regulation 8 gives us two rules about breaking a deadlock. The first one says that if you get the same number of points, total number of points, then the deadlock breaking mechanism is that the one that scored the highest on the specific goals points would be the winner. But if they even equal on the specific goals point, then A2 tells us that we draw lots. So A2 specifically, the wording is, if two or more tenderers score equal total points in all respects, the award must be decided by the drawing of lots. This is what Eskom did. They landed in 2. But importantly, the way they calculated who is eligible in the drawing of the lots. So in other words, the way they determined whether there was an equal total points in all respects was to look only at the price and preference points. So they only looked at the stage 3 points. On that approach, Mpuzi lost out. But Mpuzi's argument was that you should also look at functionality. Right, so the question thus before the court is, how should you determine whether there's an equal number of points in order to apply Regulation 8.2? And here are the two arguments. It really turns on this question, what does in all respects mean in Section 8.2? And there are two interpretations proposed to the court. Firstly, only price and preference points. And this was Eskom's argument, the first respondent's argument. Eskom says, when Regulation 8.2 talks about equal total points in all respects, it means equal total points on price and preference. When we combine those two, they are the same, and they're the same individually as well. The applicant, Mpuzi, says no, that's not the correct interpretation. The correct interpretation of the term in all respects includes functionality. So you should bring functionality also into the 8.2 determination, and it's only when with functionality included that it's all equal that you draw lots. And this is the question that the court needs to decide in this matter. In the end, the court opts for the second interpretation. And this is now really where the debate comes in. The effect is that the court thus pulls functionality into the award stage, the actual points on functionality. So with this move, functionality acquires a different role, an additional role in the adjudication process. It is no longer just a filter to determine which bidders can indeed fulfill the need. It now also becomes part of the mechanism in terms of which we rank or which we differentiate between bidders in order to pick the winning one. So functionality in the second interpretation or quality now has an impact on who wins. On the first interpretation, it would not. And the court says this is how we should use functionality. Now, in reaching this conclusion, the court makes a number of very interesting remarks, which I think is highly relevant for our conversation. I've just pulled out two paragraphs for you, paragraph 40 and 41. So this is what the court says in arriving at this conclusion. The court says, furthermore, the first respondent's interpretation, right? So remember, that's the one that says only price and preference points. This is what Eskom did. Is not consistent with the objectives of Section 217 of the Constitution, as it did not award the tender in a competitive and cost-effective manner. Furthermore, it is also inconsistent with the first respondent's own vegetation management plan, which strives to be economical. Paragraph 41, taking functionality into account during the second stage of the deadlock breaking mechanism would make the tender process more competitive and would ensure that the successful bidder would also be able to perform and meet the needs of the first respondent. It would ensure that the award of the tender resulted in the best possible value for money being achieved. This yields a sensible and commercially sound result. And as a result, the court said, therefore, after considering the legal principles and factual context, I am of the view that the phrase in all respects as used in the deadlock breaking mechanism in the invitation of tender, that's basically Regulation 8, refers to functionality, pricing, and specific goals, all three of them together. Now, this I find very interesting. And let me just put my cards on the table. I'm not convinced. I don't agree with the court. Now, let's unpack this a little bit to understand, firstly, in terms of our existing legal framework. How do we understand this? And to do that, we need to just remind ourselves what the criteria are and how they're set out in the South African public procurement system currently. And of course, we all know that is determined by the PPPA and more specifically, the Preferential Procurement Regulations 2022. And when we go look at those regulations, this is what we find. We find that the regulations only talk about price and preference, specific goals as the award criteria. You decide based on price and preference. That's the only thing that the regulations talk about. Importantly, the 2022 regulations are silent on functionality, not a word on functionality in the 2022 regulations, right? Nothing. That is in stark contrast to the previous set of regulations, the 2017 regulations, which explicitly provided for functionality to be taken into account during the adjudication process. We had a Regulation 5 that said, this is how you go about using functionality in your tender process. You don't have to, but if you do, this is going to be the way that you must do so. Very important for present purposes. Regulation 5 of the previous set of regulations said that the tender document, in a case where you're going to assess for functionality, must specify the points for each criteria and, if any, each sub-criteria, right? So under the 2017 regulations, it was clear that if you're going to use functionality in your tender adjudication process, you had to do so by way of a point system. And you had to define and set out that point system in your tender invitation. But the 2022 regulations are silent on this. They omitted that regulation, that provision from the 2022 regulation. They did not carry it over from the 2017. And that, of course, is meaningful, right? It tells us something. With that move, the notion of functionality, even the word, has now disappeared from our procurement law because it only ever existed in the regulations. The idea, though, is still possible under the PPPA itself. So quality, or then we're using this word functionality, was possible under the previous set of regulations on one of two bases in terms of the PPPA. either as an expression of what is an acceptable tender. So the Act, the PPPA, defines an acceptable tender as any tender which in all respects complies with the specifications and conditions of tender as set out in the tender document. That opened the door, that created the possibility that you can in your tender document say, these are the substantive criteria I want you to meet, including the quality criteria. This is the specification. This is how I'm going to measure whether you are offering me what I'm asking for. This is my methodology. That fits into this notion of an acceptable tender. And this one part of it became known as functionality as part of the acceptable tender evaluation. And when you read the rest of the PPPA, you'll see that the PPPA says you only adjudicate acceptable tenders, nothing else. Right? So that by implication tells us that the PPPA allows for this upfront filter, a qualification filter, if you like, that allowed us to do this. And it was on the back of that the 2017 regulation then created this notion of functionality. But it's not in that, right? It opens the door, but it's not prescribed in that. The second possibility would be under the other objective criteria. You all know that under section 21F of the PPPA, it tells us that the contract must be awarded to the bidder that scores the highest number of points. That's price and preference points. Unless there are other objective criteria that will justify the award to somebody else. We know the jurisprudence under that has now told us that you can do that, you can set that up, but you must do so in your tender invitation. You must say upfront, these are the other objective criteria I'm going to use, and then those are the only ones that you can use. But when you do that, you can completely override the price and preference points. You actually go to a fourth stage. And there's nothing in the PPPA that prohibits you from including quality or then functionality as other objective criteria. You could do that. There's no reason why you couldn't do that. So again, it opened the window, opened the door to bring quality in. And these are the two mechanisms that the Act allowed for. Now, under the previous regulations, Treasury, the minister, picked the first option and said, this is how we deal with functionality. Under the new regulations, the minister made no choice, left it open, silent. That means a procuring institution has now got the freedom to pick between these options or use both of them. Right, so you can either build it into your acceptable tender mechanism, you prescribe it, this part of the specifications, you say how you're going to determine whether somebody's got an acceptable tender. It allows you to measure quality upfront. You can, or alternatively, you can say, this is how I'm going to measure functionality, and I'm going to use it as objective criteria in a final stage of adjudication, or you can do both, right? Do both. There's no reason why you're forced to do one or the other. I see a question on the chat. Let me just clarify that. Eskom's tender in the matter is issued under the 2022 regulations, right? It was done during 2024. So Eskom's tender was done under the 2022 regs. So with this by way of background, let me then quickly just give you my views on analyzing the judgment. And I think there are two parts to this that one should apply your mind to. The first one is simply, how do we interpret Regulation 8.2? This is perhaps the less interesting and not such an important one. Of course, for the moment, it does tell us how we need to go about it. But in terms of principle, I don't think this is as relevant. But let's just unpack that. So the question here is, what does it mean when we say the points are equal in all respects? That's really the question that the court had to answer. That's the interpretation. It all turns on the question, what does the term points in Regulation 8 refer to? Does it refer to only the price and the preference points, or does it also refer to functionality? And as you would have seen, the court interpreted it to be the latter. The court said, when we talk about equal total points in all respects, that includes functionality. Now, I've got very serious reservations about that. I, with respect, think that's incorrect. I don't think that's the correct interpretation of the regulation. Right? So I'm not talking about whether this is desirable or whether we want to do this. I'm just saying, is this what the regulation means? I don't think it is. I think the court is wrong. And my reasoning for that is based on the question, what does the term point means under the PPPA regime? That surely must give us the answer. And when we interrogate the entire PPPA regime, including the regulations, as they stand now, the 2022 regulations, the word point, or points then, plural, is only used, very specifically only used, to refer to the price and the preference points, not to anything else. Very specifically, not functionality. And remember, functionality is now in any case disappeared from our legal terminology. To use the terms of the PPPA, from a determination of what is an acceptable tender. So if we look at the PPPA, we see that it talks in section 2(1)(b)(1) about this point system. This is where we get the point system. And it says explicitly there that for contracts with a rand value above a prescribed amount, a maximum of 10 points may be allocated for specific goals, the remaining 90 for price. And you know that there's the equivalent for the 80-20. Now, to my mind, it's very hard to see how can we now talk about additional points, right? Because if we follow this court's interpretation that points also include functionality points, how do we get past this maximum 10? Because now there's going to be more than 100 points. And we're no longer going to have the 10 and the 90 in that relationship for price and preference. They're going to be watered down based on the new total. That to me is directly in conflict with 2(1)(b)(1). We know that a regulation cannot go outside of the Act. So in my view, the court's interpretation simply of what the word points mean in the regulation suggests an interpretation that goes beyond the Act. That's not consistent with the Act. That just cannot be. We can look at other examples from the Act as well. Look at section 2(1)(c). 2(1)(c) says, any other acceptable tenders which are higher in price must score fewer points. Again, that only makes sense if we bear in mind that points here is limited to price and preference points. Otherwise, that's not going to be the case. And you can go through the rest of the PPPA and you'll see the same story over and over again. I've already shown you 2(1)(f), where it says that bid must be awarded to the highest score points, unless there are other criteria. That highest score of points, without any doubt, refers to the combination of the price and preference points. And we've been here. We've had this conversation years ago when on the very first set of regulations, the 2001 regulations, the original version included functionality as part of the point score, and the courts have invalidated that. In Siyabonke Civils out of the KZN, the court said that's unlawful under the Act. The Act does not allow for that. And now we seem to be back there. Another problem with this interpretation is the fact that that the regulations, of course, is silent on functionality. So unlike the 2017 regulations, the 2022 regulations say absolutely nothing on functionality. This means that organs of state now use the definition of an acceptable tender in the Act to guide their design of however they're going to determine quality or functionality. And there's no obligation to use a point system at all. It was only the 2017 regulations that spoke about points in relation to acceptable tender via the functionality mechanism. That's now disappeared. So as an organ of state, if you want to insert functionality now into your assessment, you are not obliged to use a point system. You can use any other mechanism. So again, how would points then play a role? If we accept this court's view that functionality plays a part in the total number of points, how are you going to deal with a case where you test functionality without reference to points? You don't use points. So again, to my mind, it shows why that reading, that interpretation is wrong. It is not the correct interpretation. That section only refers to price and preference. I think the court made way too much of the fact that in this case, the only differentiation in points could ever be on the preference points because of the fact that the price was fixed. The effect of that was that it was much easier to arrive at a deadlock, and the two deadlock breaking mechanisms amounted to the same thing because it's only preference points that differ. But that doesn't matter. That makes no difference. That's just within the very particular context of this tender where price was fixed. That was simply the effect. Makes no difference. That doesn't change the interpretation of the section. So I think the court just simply didn't properly interpret the regulation. But as I said, this is probably not that interesting. I mean, it's obviously of practical implication for the moment, but this, as we know, is on its way out. The bigger question is the second one. And this is the one that really interests me. Because the question really is, how do we deal with quality in our system? What view do we take on quality? What policy position do we take? And this takes us back to this old case, Rainbow Civils. In fact, in the Mpuzi case, the court referred to Rainbow Civils. It cites it. And Rainbow Civils is the strange case that's never really gotten a lot of traction. But in Rainbow Civils, the High Court said, in the context of other objective criteria, right? So it's a different context. But it also dealt with functionality. And it asked the question whether you can use functionality under 2.1f as other objective criteria. And in Rainbow Civils, the court said, not only can you, you must. You are obliged under 2.1f to look first again at the functionality assessment right at the end to decide whether those functionality scores amount to objective criteria that would justify award to somebody else. As I've said, that case has never really gotten much traction. I've also written on that, I've written an article on that where I've also argued that's wrong. The judgment is wrong. That is not the correct interpretation. But when you read the Rainbow Civils, you will see that it's got the very same reasoning that we find in Mpuzi around value for money, cost effectiveness, competitiveness. There's this notion that these judges seem to adhere to that you must have quality in your final choice in order to have value for money, cost effectiveness, competitiveness. They seem to take a categorical view that it's impossible to arrive at cost effectiveness and competitiveness and then value for money without taking quality into account right at the end. Now, I think that's wrong. And there are many examples around the world of different procurement systems that surely pursues value for money, that implements the principle of cost effectiveness and competitiveness without bringing quality into the final award decision. It's a matter of design. It's how you arrive at your cost effectiveness analysis or your competitiveness analysis, or then value for money as the overarching term. It doesn't per se tell us whether we've got one or the other. These are different methodologies of arriving at the final conclusion. Let me just quickly show you how I've always understood the logic of our adjudication methodology and why we picked the one we did. And it's perfectly rational and logical in my view, and it perfectly aligns with Section 217 in my view. It's not the only way. There are definitely other ways as well. But I don't think that it's a valid argument to make to say that this system where the way we've got it does not comply with cost effectiveness and competitiveness. So this is the way the logic works in our system currently. We take all bids that we receive and we filter them to arrive at a subgroup called the qualifying bidders. And we use functionality to do that. Right? That is in the first stage, it's a filter. So we put everyone through that functionality filter, and only those that make it through that filter then proceed to the next level. What is the effect of this? The effect of this is that anyone that's now left on the table can provide you with the goods and services you need. Right? So we use this threshold mechanism. We only allow those through that meet that criteria as we've defined them. And the logic of this is that we are happy to contract with anyone that's now left on the table. So with other words, put differently, nobody that's still now on the table, that's now a qualifying bidder, or to use the PPPA terminology, an acceptable bid, none of them should fail us in our supply. That's the logic. If you at this stage pick one of these qualifying bidders, you contract with them, but they cannot fulfill your function, what they're offering you cannot meet your needs, then your functionality assessment was wrong. It was either set incorrectly or you did it wrong. Because that's the purpose. That is what the functionality assessment is supposed to do. It's supposed to filter out everyone that cannot fulfill your need. After you've applied that filter, the only thing left should be those that you are happy to contract with. That's the logic. Then we take that group, the group that we can contract anyone with, doesn't really matter in terms of fulfilling our need. The lowest quality on the table now will still meet our needs. Then we apply price and preference. And we do so in order to rank the qualifying bidders. To see, okay, so amongst these bidders that can fulfill our needs, how do we rank them? And we've made a policy choice about how we're going to rank. By far, we do so on price. So what we're saying in our system is we don't want to gold plate. That means we don't want to go for the highest quality item. And that's perfectly rational. We are resource constrained. We want to go for the lowest priced item that can fulfill our need. Remember, that's very important. Because everyone we're looking at now can fulfill our need. So now that we've guaranteed that, we've ensured that we only look at those that can fulfill our need. Now we want to spend as little money as possible so that our resources can go as far as possible. That's the logic. And then we add the preference part on it as a policy consideration. That's the logic, and it's perfectly logical. But we've still said, look, there might be good reasons why, in a given case, we want to override this logic, and then we've created this backdoor of objective criteria where you can actually then pick a lower ranked bidder. So if you say, look, in this case, this element is so important that I actually do want to pick the little bit better one. Let's say the price quality ratio is so small, the difference is so small between different bidders, but the quality is so much better that you say, I will pay the few extra rands to get quality that's 3 or 4 times. And you can do so. As long as you've written that into your tender document, you can do so. So you see how this is a perfectly logical system. It's perfectly competitive. It's highly cost effective. In fact, it's more cost effective than now allowing quality to come into the picture and to really override price in any way. Right, so that's the current scenario. Let me then say 10 words about where we go. And this is I think where the thinking must come in. The new Act gives us a complete clean slate in this regard. This is the only real provision under the Act, Section 24(1)(d), dealing with criteria. And you will see that it simply authorizes both the minister in the framework that the minister must create, and then procuring institutions in the system that they must create within this framework, a system about criteria. It's up for grabs again. We can reconsider. And I think that's the conversation we must be having now. We must ask ourselves, does the logic of the current system still hold? Is this still the principle we want to pursue? So we want to pay as low amount as possible to meet our needs. So we're not going to go for anything beyond meeting our needs. Then we are price sensitive. Of course, we're not going to contract with somebody that cannot fulfill our need. That we want to do upfront. That's why we set the functionality criteria. But once we are satisfied that bidders can fulfill our need, we want to spend as little money as possible. Is that logic going to hold? Because if it does, then it tells us how we're going to deal, and we have to deal with quality going forward. But it might be that we say, no, we want to adopt a different approach. We want to bring quality into the adjudication methodology, and we want some other mechanism. And there are other options available, right? Other systems, it's got different formula and different principles that they bring to bear on this analysis to arrive at some balancing of quality and price, for example, or other considerations you can bring in as well. And we can look at those. But we need to first ask this upfront point of departure question when we are now going to go into a redesign. All right. Henry, I'm going to stop there. There's been a lot of comment that I've not been able to read while I was presenting on the chat. Clearly a lot of
yes.
Views on this. So let's open the floor and let's get some views.
Yes, I think so. Thank you for that, Prof. So far. Let me just start with some of the comments. So you've already addressed the first comment. The second comment was from Chris. Chris, you're more than welcome to unmute. But you basically talk about the 200 points. I think it's separately. It's not combined 200 points. I think it's 2 separate things. But maybe you just want to. You're more than welcome to unmute, Chris, if you want to just clarify that point about 100 points and then another 100 points.
Thanks, Henry. I just found it curious when I was reading the judgment that Eskom themselves spoke about awarding 200 points, and all the 9 that had 200 points then went to the deadlock breaking, which was the drawing of lots. And I don't understand their reasoning how they award 200 points, because after the functionality phase, those points are supposed to be discarded. And then only as Prof's previous slide showed, only those which passed functionality would get 80 plus 20 or 90 plus 10. So theoretically, there should only be 100 points. And I'm not sure how they awarded bidders up to 200 points. That was just something I found curious. It's more just a comment rather than a question.
Okay.
Chris, I mean,
Prof?
just quickly on that. I also, from the judgment, one can't quite figure this out. I mean, I know both sets of advocates who are involved in this matter. I can certainly ask, and we can try and get some closer views on this. So it'll be interesting to see what was the methodology? How did they get to that? The argument in court was certainly that they're only looking at price and preference. They're discarding those functionality points from the earlier round.
I think SEPA's also just making a statement towards the second point there, just saying that minimum percent criteria opens a lot of room for less quality. Not sure if there was a question there, SEPA. There's more comment from you.
Yeah.
Andre's, yeah, sorry.
Yeah, no, look, I believe so, because if you look at the functionality stage in most cases, some bids will say you have to meet a minimum of 70%, and one bidder will meet 70, which means they progress to the next stage, and one bidder will meet 99%. And when you're gonna maybe do the total, points, you find that they're equal in all respect. And now the question is, based on the 2017, how we used to apply it was that the functionality was part before we do the drawing of lots or tossing of the coin, and then you look at which one has got the highest functionality. And in that way, it is somehow addressing the quality as an objective decision rather than a subjective, because one would ask him or herself whether the BMW and the Mercedes, which one is quality? And the quality statement or judgment there would be based on personal experience. So yeah, I somehow convinced with the judgment. However, based on the lot of loopholes that the 2022 PPR has, which was rushed into implementation, I think there was somehow limitations to that, yeah, which caused a little bit of, confusion. Thanks.
Andre also seems to agree with the judgment. Indirectly, it sounds, Andre, in terms, because they mentioned the points. I think that the danger is here that Treasury most probably comes back to this cut and paste thing. They should most probably not use that all respects. But I also hear your argument, Prof, that you made earlier when you talk about the total points and in the context of the Act. Andre, after Prof explained his rationale for why he thought it would be, why I thought that is the only points that it talks about. Do you still agree on what you had here to say it should still have been regarded? That in quotes the functional points. You're more than welcome to unmute. And for some reason, it seems as if you're unmute, but we can't hear you. He's gone. Okay, so when Andre comes back in, I'll give him a minute to talk. Okay, so while I'm reading through some of the other comments, Advocate Nchaluba, you can unmute.
Thank you very much, and good morning to everyone. Thank you, Prof, for, I think I like your slide on the flow chart. But Prof, I would want you to talk to the slide as it applies to innovation. As you know, that innovation is having its own processes, and it's multi-layered. It has stages, your prototypes, and you move and you move. How would you see the same flow chart applying then to innovation? And I'm asking this precisely because you've just got to the regulation that deals with this, and we need to make sure that the development of that delegated legislation does not focus only to the normal day-to-day procurement processes and bidding. It must encompass all sectors that have varied forms of procurement, like for example in the military. So how do you see then the same flowchart, beautiful flowchart, applying then in the case of innovation, where you are having various layers that are dealt with differently? And in the mix, you even have PPPs. Thank you.
Yeah, Henry, perhaps I should just quickly respond to that. I mean, so I think, in my view, one of the best ways to deal with functionality in the ordinary course, right? So not thinking about things like R&D procurement and that kind of thing. Just how do we get innovation to be embedded in the ordinary course across our entire procurement function? I think the best way to do that is actually also with functionality, but then using functionality not in the way that we use it in South Africa, using it in the way that it's used in the international literature, which is to say, when you define, when you describe, set out your specification, you should always try and do that by way of a functional description rather than a product description. So you should always try not to go to the market and say, I want product X, give me product X. But you should rather go to the market and say, I need the following function to be fulfilled. Please make me offers in how I can achieve that function, that purpose. And then you open up the door for the market to respond with innovation. So one person will come, one bidder will come with one solution, another will come with another solution, and et cetera, et cetera, et cetera. And you still have your objective criteria in how you're going to measure the quality of these solutions, but you measure it with reference to fulfilling the function, achieving the outcome. So Charles Edquist and I published an article in January this year on this very notion, where we show that small shift in just how we think about the description, the kind of formulation of specifications, is an incredibly powerful way of bringing innovation into the picture. And then when we use this diagram, once we filtered, right, we are left with a number of bidders that can be highly, highly innovative, right? We can build into our functionality assessment there the level of innovation. How innovative is the solution? And that would not only allow innovation to enter into the system, it would indeed reward innovation, right? You are then more likely to achieve the pass rate in the filter to go to the second one if you're offering innovation. But of course, under the new system, we are no longer limited to the price and preference mechanism during award. Not that we ever were, right? It's a complete misunderstanding. It remains absolute puzzle to me that we've got 25 years of the PPPA. The PPPA has never limited us to price and preference in our award decisions. It's always allowed the 21F other criteria, and yet we seem to be kind of, laboring under the impression that you can only use price and preference. No, you just use price and preference in this one stage. But under the new Act, it's even more broad. As you know, that the Act explicitly says that innovation is one of the policy objectives. So it must be built into the system. And I think then bringing innovation into the award stage would also be a really good idea. Building in some understanding about the contribution of that innovation for the bigger system. Then we can start to think about things like procurement as lead markets, as earlier adopters, shaping the market, all of that. So I think those are probably the best ways to bring innovation into the sector. There are, of course, other more sophisticated ways, pre-commercial procurement, PPPs, as you say. There are other mechanisms. I would, as always, caution against going for the more difficult, kind of sophisticated, very tricky mechanisms. We can have those for the really mature entities in South Africa. But I think if we're talking about kind of across the system, run-of-the-mill, I think opening up to functional criteria is a really powerful first start.
Thank you, Prof.
Thanks, Prof. Prof, just before I go then on to, I know Aspel, there was a hand up. I think he just dropped it now. And then I also know Michael's got his hand up. But just before we go there, Tsepo, and I think you, as I said, you did explain your rationale for the number of, why you say the total number of points only pertain to that. So Tsepo then made a comment and refers back to the previous regulations. My view is that previous regulations are gone, but maybe you want to, you just want to respond maybe on Tsepo's point there.
Yeah, I mean, I think that's the point, that the previous regs are gone. I would have argued that those previous regs were probably unlawful for that very same reason. I think they tried to force a methodology into the Act that the Act does not allow for. So my interpretation of Regulation 8 now is premised on an interpretation of the Act itself. I think the word points means something in the Act, and then by necessary implication must mean the same under the regulations. That, I think, was also true under the previous regulations. And I think for that reason, the previous regulations were unlawful in trying to force functionality also into a point score. I think it was a repeat of the mistake of the 2001 regulations, which the court did set aside. So I don't think one can just circumvent the in my view, fairly clear, limited meaning of the word point in the Act by now saying, oh, well, you know, we previously said it could be this and now it could be that, or as well. Or even worse, referring to an individual tender invitation and saying, well, this tender invitation talks about points in relation to functionality. That means that when we get to deadlock under Regulation 8, we must also take that into account. I mean, the meaning of a law cannot be determined by the implementation in an individual tender. There must be a meaning outside of any individual invitation to tender. And it's arriving at that meaning that I think the court made a mistake in saying that it includes functionality. It practically cannot include it in the way that the law is written now, because it wholly depends on how you will determine functionality. You don't have to do so by way of points. So I don't think that makes any difference. That is not to say, and I need to emphasize this, that's not my position, to say you cannot bring quality in at the tail end. You can, absolutely. I've got no doubt about it. That is what Section 2.1F allows for. But then you do so under 2.1F, not through this back door of a deadlock breaking mechanism or some other thing. You do it properly under 2.1F. There's a whole mountain of jurisprudence on 2.1F. We know how to do 2.1F now. Then you do so. You say that from the start. You say, once you've done your price and preference evaluation, you are going to look at the functionality scores, and this is the way you're going to do it. And if there's a differential bigger than this, then you're going to go for that rather. No reason why you can't do that. But you need to be upfront about it.
Before I go to Michael and to Asfa finally, maybe just to pick up Aideen's Ebro's point here. So so they qualified, but now afterwards, just before award, they now one of those conditions are no longer met.
Yeah, Adine, you always ask the most difficult questions. So I should throw that back to you and say, you're the construction procurement expert. You tell us. This is very difficult. There is, to the extent that we've got authority on this, it's very similar to the BE and tax certificate thing, although I note your point, which I think is an important point, and that is that the fact that you're not paying doesn't automatically mean you're out, right? So it's different in that respect from tax and BE, where when your certificate lapses, it lapses, and you have to get a new one. This doesn't seem to me similar, although I'm definitely not an expert on how the CIDB system works, but just judging from what you've got here, and you must please come in a moment, it seems to me that this is something that you can still rectify. So it's a temporary kind of change in your position. The general rule of thumb that we've had from the case law is that you judge on the date of submission. That's the relevant date. There have been a couple of cases where the courts have extended that to the validity period to say it's the date of submission and then up to the end of the validity period. For that whole period, you need to meet the qualification criteria in order to qualify. If during that period, you then fall below, you no longer qualify and you must be excluded. I've not always been convinced of that reasoning, because I think that puts way too much on just how quickly an adjudication will happen. I mean, it might be that in one case, the adjudication happens quickly, you are awarded the bid, and you are still tax compliant, even though you're not at the end of the validity period yet, and your certificate would have lapsed before the end of the validity period. I'm also not convinced about the implication that would mean that when there's a compliance checking up front, that you need to check not only that you complied with the qualification criteria at the date of submission, but then for the rest of the validity period as well, that's part of the compliance. I'm not convinced about that, because we all know that validity periods can be extended. And I can just see the abuse there. I can see how, if you want to abuse the system from the inside, you just look at the bits, you see, oh, this guy's certificate is going to lapse a week after the tender validity period. Let's extend it with a week. Then he's out. So I see all kinds of reasons why I don't think that that's a good idea in general. And I would apply it to your case as well. Even though I think your case, there's probably a stronger reason to argue that it should not be a disqualification, because you can still rectify it. I would say that would be the type of scenario where the procuring institution needs to approach the bidder and say, look, there's a problem here. This has now emerged since you submitted. You were compliant. Now you've become non-compliant. Can you fix this? And if they can, they should be allowed to do so, because it does not change the competitive position at the date of submission. That's the key. So my view would be that should be rectified, but it's not, I can't, state that as a definitive view that would always carry the day. I think there will be differences, but perhaps you can help us a little bit with the state, your CIDB status, and whether that's a temporary thing that can change.
Thanks, Prof. I mean, why would I give you something simple? It's not simple for me either, even as the construction professional. And this is actually, I obviously can't go into the details, but this is an ongoing matter, and it's causing substantial problems for a particular organ of state. And, I'm coming from a very particular point of view, from a construction point of view in relation to procurement. But it just struck me, and I really wanted to hear you today in relation to, this deadlock mechanism, because I think it only ought to apply in relation to, your price and preference. If we look at the process as a whole, and maybe going forward and looking at the regulations, and I think it's very much a matter of the wording of the bid document, which is so important. I don't think we can ever underestimate, as you've mentioned, the wording of the bid document to get an interpretation. But the wording of this particular bid document is at submission. It's at submission, and we've got a unsuccessful bidder who's tying up, well, it's just a terribly important project. They all are, but in relation to something like this, and it shouldn't be that this should be a fight in our courts. What I'm saying is, in our regulations, in the things that we change, and particularly from a construction point of view, when we look at CIDB, I mean, yes, I can tell you, it says you're suspended. It says you can't trade, but what does that mean? And Prof, the thing is, the organ of state have done that tick box exercise. And so at award, they're not looking at it again. Nobody has that time, that capacity.
Absolutely.
We don't have that. It's just not out there for us that every time, if you met the eligibility and you move on to the different aspects, where there's something like this, which can simply be, as you say, changed with the click of a button and a payment to be made, which is relatively insubstantial in the big scheme of things. It just shows me, and I'm so grateful for listening to you about the other aspect, and then also just to bring something like this up in relation to eligibility criterion. And does that mean it's an acceptable bid and the award can made or be made, or do we have to then start going back and checking everything? It's really something to behold, and something that I'm quite excited about seeing in the regulations, or in our new regs. And just to bear in mind, if you could be my expert, that would be great. I'll accept your bid submission. But no, thank you. Thank you to you and for everybody organizing it, and also for everybody else just listening to me on this aspect, because I just think, this is not the only aspect where this is going to come and is coming up. And this is just from an attorney in this profession, and seeing, it doesn't only come up in this instance, it comes up in multiple instances, and even at eligibility stage. So thanks, Prof.
Thanks, Adine. I mean, I think, you make a lot of, I think, very valid points. I mean, just two very quick comments. I think the first comment is, we need to remember why we're doing these things. And it cannot just be because it's written on some piece of paper. That is never a good reason. We need to remember that we do these things for a purpose. So if we require CIDB grading, we do so not just because we do so. We do so for a purpose. And I think we need to always ask ourselves, how is that purpose going to be achieved by how I deal with whatever curveball I've now been thrown in the process? And I think that is so critically important. If we say to each other, look, we require CIDB grading because it tells us something about the ability of the bidder, right? It's a proxy for quality. Then surely, if that bidder can show us that it meets that criteria, this is something, it's got nothing to do with its ability, the fact that it's now suspended, and we can get that back on track, we can get that certification back, then surely we should allow that bidder in. Surely then, excluding that bidder then becomes about forcing payment to the CIDB system. Now, how is that part of the purpose that we are trying to achieve in procurement? That's got nothing to do with it. It's irrelevant.
Agreed.
And I think that's the kind of thinking that we need to bear in mind all the time. The other important point about what you made that I think we really, really need to think about now as we're sitting with this new regulation exercise is the point that, I mean, Chris also made it, a couple of people have made it now, that we really need to look so carefully at how these regulations are going to be worded, actually the words that we use, because they've got consequences. So if we say something in this case like equal points in all respects, what does that mean? Do we have clarity in our minds about what it means? Is there a different way that we can frame that to just ensure that we don't end up in these ridiculous kind of, you know, court cases where really we end up in court because we can't agree on what the words in all respects mean? That seems to me to just be mind-boggling.
It absolutely is. And in each and every one of these cases, it's an interpretation issue. Why should we leave things open to interpretation, Prof? That is like 100%. I can't agree with you more. And I think that's also where a lot of other people are coming from. If something's open to interpretation between you and me just reading the regulations or the revised regs, then I don't think we're doing our job.
No, absolutely.
Together with your purposive approach. You know, which we see. Yeah, no, fantastic.
And this is as you know, some of the colleagues also said just now that you know, I think I'm just scrolling up here. You see, somebody made this, Chepo, I think, made this point that, you know, it really does come from how do we draft a new regulation? Do we just cut and paste? Do we just roll over? Or do we really think about what does this mean? What are the implications? What have we seen in the past around this? Okay, let's draw those lessons into the new exercise, and let's not repeat the mistake. Let's now try and get something better. I think that's the opportunity we've got now, is a golden one to go through these kind of exercises. But you know, it's not a quick fix. It's not an easy, quick, you know, we just sit for a few days and then we think we've got it. It's a massive exercise. But you know, I come back.
Undertaking, yeah.
Yeah. I mean, I come back to the point that so many of us have made. It seems to me that Parliament is still not getting that. And this is that, you know, this is not small change we're talking about here. This is R1 trillion every year, talking about a budget that must be, you know, balanced today. We need to be serious about these things. We need to treat it with the necessary attention. And I'm not always sure. But anyway, so I mean, I think conversations like this are really important. Sorry, Henry, I'm going on too long.
No worries,
Thanks,
no worries.
Thanks.
Okay. Right, then maybe let's give Michael quickly. Michael's hand's been up for a while. And then as we were finally, if you want to come in, you're more than welcome to unmute after Prof responded to Michael.
Prof, I'd like to make 2 points. One is what leaves me flummoxed is how the state seems to make the same mistakes over and over and over. Bids, courts have upheld conditions of bid where the conditions of bid are clear. Where they're unclear, then they provide interpretations as to what the words mean. If you intend to disqualify somebody, all you have to do is put a date on there. You need to be registered with the CRDB as of the date of, and that's it. There are no challenges on that because it's crystal clear. And you know, having been involved in the construction sector for the best part of 40 years, we see these issues appearing on a never-ending basis, and one wonders why they are not being addressed, because it's just like it's not even a low-hanging fruit.
Yeah.
But what I wanted to say really about functionality and value for money and all those concepts, what I do not understand is that there is a very comprehensive PPP manual or public-private partnership manual that addresses the majority of these issues in a very comprehensive and very detailed fashion as to how value for money is accounted for, how functionality is accounted for in a PPP, and so on and so forth. They're written by Treasury. So obviously it looks like Treasury's lift doesn't stop at all floors, because all they need to do is actually talk to each other and incorporate some of those concepts that have already been expanded and expounded on quite extensively and are part of best practice internationally, and bring them across. Obviously, if you are buying pencils or refuse bags, you don't need to go through the same kind of complications. But if you are procuring billion rands worth of equipment where innovation is a major issue, then you need to go through those sort of things. But it's all there. All it needs is somebody to take them and actually put them together in a document that makes sense for other procurement other than triple Ps.
Yeah. Thanks, Mike. I mean, I can only agree with you. I think it comes back to this point that we pushed quite hard last year as well at the NRF conference, about the fact that we don't seem to be spending enough time and energy system-wide on specifications. And we use the word specifications, but it goes beyond that. It goes to the whole design and planning of the acquisition, and how you formulate that, how you frame it, and then how you go into the market with that. I don't think we spend enough system-wide attention to that, so that we can learn these lessons, we can internalize these lessons, how important it is. I see a lot of comments on the chat as well. How important it is to frame that, what generally is known as the solicitation document, right? That whole package. It is really critical. Getting that right is kind of, a big part of the job done. But we tend to, I think, underestimate, not pay enough attention to that element, to our serious detriment. And then we end up in these kind of very, very unfortunate positions where we should just never be. We shouldn't end up in these kind of scenarios. They should never even emerge. So I think, if whatever we do under the new system, if we can bring just more attention to bear on that in every single procurement, if we can really bring home the message that every time you go out into the market, you need to think about this, and you need to be careful, and you need to be meticulous, I think we will serve our system. Whether that can involve some defaults, I don't know. That's the conversations we need to have. Or are there other ways of doing it? As you said, we've got options. Let's start to have this conversation. But I'm just worried that we're not. I think we too often we think we just write something down on paper as a rule or a guideline or whatever, and then we stop there. We don't do anything with it. And it's no secret that just writing up the manual or the law or the regulation in itself is not going to fix anything. Unless we give it feet, unless we make it a reality, we can just as well not do it. And that's where I'm increasingly starting to worry, that we write up beautiful things. And I mean, you've given us one example. We've just gone through the triple P new regs. Are we connecting the dots? And I think that's something that requires serious attention.
Polani, over to you. If you're more than welcome to unmute.
Thank you, Henry, and very good morning, Prof. Mine is a small one from what you presented here about this case. To me, I'm seeing that the courts answered the question of what must be done, but the question of how must it be done, they were silent. And I say that because, as you had rightfully said, that when there's a tie, the points, we understand it to talk to price and preference. So now if they are saying we should include functionality in there, how are we to do that? Because the total that we work with is out of 100. So now if they are saying the issue of functionality points must also be included, how are they proposing that be done? And I say this because I haven't read the whole case. Maybe you have privy to it to see if maybe they go into details now as to how that particular part they are saying should have been done, because I believe Eskom's case was built around what you also shared, that they are saying according to legislation we have now, points is talking to price and preference. If the court has a different view, did maybe they give light as to how must that be done? Because I think this case will be problematic for us practitioners on the ground, because most service providers now are really putting their eye on such cases. So now someone will be aggrieved on a particular tender in an organ of state, and then they'll want to invoke this case law. How do we move forward now? Because it's here, and as one colleague had rightfully asked now, that who can challenge this? Must it be the office of the OCP, or must it be National Treasury? Because us as organ of state in our different capacities, we can't now go and say we want to challenge this case, because it's going to be a problem for us now, because how will we factor in that preference points if the court is seeing it must be factored in? Thank you.
Yeah. Thanks, Kulani. Look, so firstly, no, it's typical of courts. They don't concern themselves with the practicalities of their judgments, right? So there's no indication. And yes, one can say in this case it was necessary for the judge, because in this particular case they did measure in terms of points functionality, so they had scores that they can go and look at. But as I've said, that's not a requirement, right? You can design a procurement process with functionality and qualification criteria that's got no point system whatsoever. So what do you do then? Do you then just ignore this, or what? I don't know. I mean, the court does not explain that. So it's highly problematic, and I think it's unworkable, to be perfectly honest. My proposal, and I don't know who should challenge this, right? We don't have that kind of body. This will now be for the next losing bidder to take up, and hopefully the case will go to the higher courts, and the courts will give us some clarity. But the way I think that you can protect yourself, that you can manage this risk at the very moment, is to use section 2(1)(f) of the triple PFA. So write into your bid invitation that after price and preference, this is how we're going to do it, right? That this is how we're going to decide who wins. Write those objective criteria in there with scores and everything, and design it in such a way that it is either impossible or highly, highly unlikely that anyone would ever score exactly the same on those mechanisms. Then you avoid this whole mess altogether, because this case is now fixated on the deadlock breaking mechanism. The Rainbow Civils case never really went anywhere, so I wouldn't be too worried about Rainbow Civils. I think it was a weird case to start off with. But this one, I think one can avoid by just making sure you never end up in a deadlock. Because remember, you only end up in a deadlock right at the end. And 2(1)(f) allows you to insert something before you come to the end, before you, with other words, get to the deadlock breaking mechanism. And I think you can play with that. I would say, for me, if I'm worried about this, especially if you're in a fixed price context, I think this kind of scenario can very easily happen in a fixed price context. So if you're in a fixed price scenario, which most frameworks would be, I would just keep myself out of the deadlock mechanism by adding other objective criteria explicitly into my solicitation documents to say, this is how I'm going to do it right at the end, and this is how I'm going to decide. And then you just never get to a deadlock. So that would be my advice.
Thanks, Prof. To an extent, that also then deals with Nkuleko's kind of, his worry there that it's going to be disheartening going forward. Although I guess he's asking how can this be corrected. I mean, obviously Eskom can challenge this and go the whole process. That's another. But in the absence of them doing that, I guess I think you gave them some sound advice how to then continue if there's no further clarity or further movement on this particular court case or challenges.
I mean, Treasury, Henry, Treasury,
yes,
of course,
yes, Prof.
can amend the reg, right?
Yeah.
They can issue a new reg, but you know, whether Treasury's got the appetite now to make this small little change in the preferential procurement regulations while we're actually working under the new act, I doubt it. I think it's energy not really worth at the moment spending on this. But of course, who knows? We know that there's a challenge to the Public Procurement Act in the courts at the moment, so we might still be stuck with the system for a couple of years. Who knows? Then it might become useful. But for the moment, I would say I wouldn't spend my energy on it if I were Treasury. I would say let's try and get the new PPA in place, and then all of this will be history in any case. But in the meantime, I think let's as practitioners try and avoid ending in a deadlock altogether by using 21F.
Thanks. Thank you. Sean I thought Sean is not available, but Sean had an interesting comment there, or a question for you. So can we then use the highest scoring bidder? So, you know, can we use that as a mechanism?
Yeah.
So yeah, especially where price is.
Absolutely. The act, and especially now that there's nothing in the regs about functionality anymore, the act is the only requirement under the PPPFA is that it must be objective. And we know from the jurisprudence, you must state so in your invitation, in your solicitation document. You can't decide after the fact. But if you meet those two things, there is no reason why you cannot say, we will go through all the processes, and then after we've done price and preference scoring, we will look at who scored the highest functionality. No reason why you can't do that. The Act allows for
it. Just looking at some of the other comments, anybody still wanted to raise their hand? I think most of them are comments. Advocate Msoluba had a question there, but I think that's more as we're going to the statutes to form part of the procurement program. Yeah, I'm not sure where that will fit in.
Yeah, I think Lucy makes a really good point in the last comment there as well. And obviously, this is something that we've recently discussed in the stakeholder groups around the regulation drafting process as well. And that is really thinking very carefully at that initial stage, when that document that's now going to be the blueprint for the entire process, when that thing is crafted. How do we do that? When do we do it? What does it involve? And I think you're absolutely right. You know, more thought needs to be put into that, which includes really thinking through all the dimensions and making sure that that document you put out actually connects the dots. That there aren't, you know, parts of it that's just not talking to other parts, and you end up in these very messy scenarios. And for that purpose, for example, some of the recommendations that's been given through to Treasury is to not talk about a bid specification committee anymore, because that's a misnomer. That's too narrow. It should be something like a bid sourcing, a sourcing committee, or a, you know, sourcing planning committee, or whatever you want to call it, to capture the broader function that body is supposed to fulfill in an individual procurement, exactly along the lines you're suggesting here.
Okay, so there seems to be there's another hand up. Samuel, over to you. You're welcome to unmute. Samuel, you are welcome to unmute. Okay, it seems Samuel's got some challenges in unmuting. In that particular case, Prof, I think we've kind of addressed most of the things. Some of the others are comments. Yeah, Andre just also reiterated the point about, I think especially in the context.
I think Henry, and I see Sean is, well, Sean's icon is here, so I think that's a nice topic for a future discussion. To talk a little bit about that point in time and the the kind of institutional functional arrangements around that point in time, and what do we want to see and where do we want to go? I think that is a very nice point to kind of explore a little bit, because I think there are good practices, good thoughts around that milling around. And if one can start to have a conversation and capture those, I think it will be quite useful when we now go into design. So I think Andre makes a really quite a valuable point for perhaps a future topic.